think council are all here for the next case, so I will call that case. This is Punturo versus Kern. It's a mini oral argument on the application, which means Mr. Koch and Mr. Zelenock, you're splitting 15 minutes. I'm going to leave it to you all to figure out how to do that and how to reserve time if you think you can do that too. And you may proceed when you're ready.
Good morning, Madam Chief Justice. May it please the court. Jonathan Koch on behalf of defendant appellant Bryce Kern. I'll be splitting my time equally with Mr. Zelenock. There are three ways that people can talk about a pending lawsuit or criminal prosecution with the news media. First, they can expressly tie their statements to the proceedings by using language like "we have alleged." Second, they can inject a added or heightened level of certainty by saying something like "we can say with certainty." Or they can reiterate the allegations from the underlying complaint without any magic words or any added certainty using declarative sentences. That's what happened here. So the issue in this case is whether a statement that repeats the substance of an allegation in the context of an interview with the news is a fair and true report under Section 2911(3). For the reasons stated in our brief, the answer to that question is yes. Here, Mr. Kern gave an account of the circumstances and underlying facts that gave rise to the Boyer's civil lawsuit and the Attorney General's criminal prosecution of Bryan Punturo. And he did so in interviews with news media that were focused on those proceedings and then published in news articles that were also focused on those proceedings. Given that context, anyone who read Mr. Kern's statement would understand that they were made by an attorney for one side of a legal dispute, and given that context, his statements would have had the same effect or on the reader, the gist or sting would have been the same as if he had quoted the complaint verbatim and prefaced everything he said with "we have alleged." This, as a result, Mr. Kern's statements substantially represented the underlying matter of public record or the contents of the Boyer's complaint, so they were privileged under Section 2911(3). This case gives this court an opportunity to rule on four jurisprudentially significant issues. First, it should hold that the fair reporting privilege protects statements that are orally furnished to the news media, so long as the speaker in some way brought about the publication, knew it would be published, or caused it would be published, consistent with this court's longstanding libel jurisprudence. Second, it should adopt the Northland Wheels substantially represents standard in the context of the privilege and hold that a statement that substantially represents a matter of public record is privileged. Third, it should clarify that Bedford was either limited to its facts or, to the extent it created a level of certainty exception to the privilege, was wrongly decided. And finally, it should hold that the privilege applies regardless of the identity, state of mind, or profession of the speaker. And before I open myself up to questioning, I want to stress that win, lose, or draw, this court's guidance is needed on these issues. They don't just affect attorneys who file lawsuits and then go talk to the media. They, as this case demonstrates, it affects their clients, real people, civil plaintiffs, and potentially even victims of crimes who talk about an ongoing prosecution. Furthermore, this court really hasn't dug into how this privilege applies or what the standard for doing so is since before the 1988 amendments. So with that, I'll waive whatever's left in my free fire zone, which I think I might be already past.
Thank you. Justice Viviano.
All right, I guess it's fitting for me to go first, Mr. Koch. I guess the question I have is, the idea that there's no difference between alleging or stating that something is alleged in a lawsuit and stating that something is true. I have difficulty with that. And I think it leads to a particular problem, which is that someone could bootstrap, defamatory statements to baseless claims that they've made in a lawsuit. I'm not saying that's what happened here, and that's no comment on the underlying litigation here, but I'm concerned if we adopt a rule that allows this to happen, that someone can file, a lawsuit and use that as a basis to make defamatory and maybe even per se defamatory statements, and then have the protection of this statute. Why shouldn't we make the distinction that Bedford makes?
So I think there's two things I want to address. The first is that I think that the real key is the context. These statements appeared in articles about the lawsuit. Anyone who read the article would know that there was a lawsuit filed by the Boyers against the Punturo, and that Brace Kern represented them, right? So in that context, I think a reader would understand that these were kind of two sides fighting over something. It might be different if the facts were that Mr. Kern had filed this lawsuit and then gone down to a restaurant or just walked into the street and made these comments just to the world. But in the context of a news interview about a lawsuit, the fact that he was the attorney for the plaintiffs, I think the context changes the gist or the sting. And to address the second point, the idea that we don't want to create a license to defame, I think there's a couple guardrails that would prevent that from happening. One, if a person did, inject baseless, horrible allegations of, into a lawsuit and then file that lawsuit just for the purpose of defaming, you could have recourse under the court rules for sanctions for filing a frivolous lawsuit, or you'd have recourse to the grievance process. You could file a grievance to that person, and that attorney could potentially lose their license. So that there are some guardrails that guard against that. On the other hand, the only guardrail for preventing the opposite problem, which is a successful summary disposition defendant or successful, from turning around and filing a retaliatory lawsuit against a plaintiff or against a alleged victim of a crime, the only guardrail for that is this privilege. That's what this privilege, appears that the legislature intended to protect. So I think that to address your concern, it's that there are other guardrails in place that should prevent that from happening.
One last question. Why is it so much to ask that somebody be a little more careful in the way that they speak about a pending case? In the criminal realm, we don't prosecutors are supposed to be, and usually are, very careful about not to make exactly these kinds of conclusions about the ultimate facts in the case, and instead to clarify that these are only allegations, our Attorney General will say at the end of her press conference, and that the defendant is innocent until proven guilty, in the court of law, those types of things. Why is it too much to ask in the civil realm that people be more careful about the way they describe factual allegations that are made in a lawsuit?
So I think regardless of what the best practice may have been, respectfully, I think the decision about how much to protect or what we want was made by the legislature, right? That the policy preferences embodied by the statute are that we want to protect these, people who talk to the media. And as the Court of Appeals has recognized, it's a close enough standard, right?
But you're asking us to give a pretty expansive reading to a matter of public record. I mean, the matter of public record here is only that a complaint was filed making certain allegations. That's a matter of public record. Until that's adjudicated, those allegations are adjudicated in court in some fashion. Whether those allegations are true is not a matter of public record yet, is it?
Sure, but the allegations themselves are also the contents of a record generally available to the public, right? The complaint, and based on how this case has been litigated, I don't believe that my opposing counsel would argue that if Mr. Kern had when he talked to the reporters had said, we filed this lawsuit, we've made the following allegations, and then read the allegations of the complaint, right, which is chock full of declarative statements that Bryan Punturo did this, that, or the other, right? He extorted the Boyers, he maliciously threatened them, and he flagrantly violated antitrust laws. Those declarative sentences, those clear assertions of criminal and civil wrongdoing are present in the complaint. If Mr. Kern had said, we have alleged this.
May I I'm sorry, sorry to interrupt, but my time is getting impinged
Well, I want to
on.
make sure Justice Viviano has this question answered, and then I was going to go to you and not go around, but I want to make sure Justice Viviano's done. So,
Yeah, no, I'm satisfied. You can.
Thank you very much.
okay. Mr. Koch, I'm going to hold you and like let Mr. Zelenock go, and then we'll see if people have questions for either of you. Okay.
Thank you very much. I apologize for the interruption. In follow-up, I think that the basic error, and I think this addresses Justice Viviano's question too, the basic error in plaintiff's complaint is, and in the lower court rulings, is ignoring this court's longstanding jurisprudence that libel is a joint tort. And we have briefed the issue that libel is, you have to review the entire context, the entire written publication in a newspaper, the entire broadcast in a TV or radio type of medium. So what the plaintiff has done here is to do precisely what this court said was not allowed in a common law case called O'Connor v. Sill, which is 60 Mich 175, and that we haven't cited, but it is cited in the Smith versus Anonymous case, which is this court's most recent addressing of this privilege. Now, in 1886, when that case, the O'Connor v. Sill case was decided, this statute did not exist, nor had the federal courts incorporated the First Amendment. But importantly, in that case, a school teacher plaintiff, Miss O'Connor, was suing the Detroit Public School superintendent, Mr. Sill, for statements that were alleged to be libelous because they were printed, his oral statements in an interview, so very, very on point here, were printed in several newspaper articles. What this court said was, you cannot take out isolated statements from Mr. Sill and claim that it's a libel action. Instead, you have to read the entire newspaper article, and actually there were several. Of course, newspapers were printed several times a day back now. Now, of course, we're losing newspapers. But they basically said, this court said, it criticized the plaintiff's declaration for relying, quote, only upon certain parts, unquote, of the newspaper article, and rejected that approach, saying the article, in order to try its libelous quality, must all be read. You can't sever isolated statements, which is exactly what's happened here. Notably, we didn't have the newspaper articles at the time of the summary disposition in trial court. We actually got them later after that hearing date and discovery and moved to expand the record in the Court of Appeals, which was rejected. Tellingly, plaintiff opposed those motions to expand the record. So I guess my point is we have a clear error here, and this is exactly the error the Bedford v. Whitty court committed to. Bedford v. Whitty got almost everything right, but what it got wrong was its final page where it says this statement, we can say with certainty, made the CBS interview libelous without analyzing whether the CBS interview made crystal clear that that was merely the opinion of one of the litigants and their advocates. There is no basis consistent with this court's jurisprudence for Bedford v. Whitty to so hold. The court here, because plaintiff didn't come forward with the publications, and I did point out in briefing, in the Northland Wheels case, it's very clear that case is dismissed on C8 grounds, and the court noted that the plaintiff tried to explain how the newspaper articles which were being submitted exceeded the scope and were not fair and true reports. Let's face it, what we have here is a newspaper article, newspaper and media coverage that there is no allegation by the plaintiffs trying to hold our clients responsible for them. There's no indication that those reports about this issue clearly of public record and also of public concern was in any way unfair or untrue. And
Council, I'm going to interrupt you. I want to see if my colleagues have questions. We've gone through 15 minutes pretty quickly. Justice Bernstein, do you have a question for either counsel?
Yeah, I do, and I guess I'll let either of them answer this question, but I really want to understand this. So, define for me the distinction between subjective and objective. Would this potentially have a chilling effect or an impact if a lawyer or a client speaks to the news press, the news media, either it's television or newspaper, I know we're talking about specifics here, but I just want to really understand, could this have an impact as to the ability for people to communicate their, not necessarily if it's, you make a, let's say you, not, what I'm trying to understand is objective versus subjective. Let's just simply say you offer an opinion as it pertains to the behavior and conduct that the defendant in a litigation has done or is doing. Could this have an effect as to the ability for a lawyer or for a client to speak freely to the news media about a case in which they're litigating?
Well, I think that this could definitely impact, both a lawyer and a client's ability to speak to the news media. And in fact, if you look at the Bedford case, it seems to apply cases where people are represented by counsel more rigorously than in other contexts. I think that what's been missing, and I think your question, Justice Bernstein, alludes to it, what's been missing in the lower court's analysis is, what about the public's right to know? What about the public's right to hear about, including from people involved in a public dispute? And the Amway court in the Sixth Circuit noted that the expansion of this privilege by the Michigan legislature was addressing the fact that the public has an interest in hearing about these issues. So I think it's important that attorneys, we've briefed that the revisions in 1989 to this statute removed the restrictions that used to limit the protection of this privilege to news media, reporters, editors, and the like. And now it applies to any libel defendant. Meanwhile, there's other parts of the statute that still talks about media publishers or media editors and reporters. The legislature didn't forget that there are media distributors and the like. So I think that their intent, as we've briefed in 1989, is, hey, if you're bringing a libel action and you don't allege and prove that it's not a fair and true report, then it's privileged. I mean, that's what the plain language of the statute says. And the reason I bring up this history of this court, I think both the bench and bar in Michigan since the 1980s or 1990s era abolition of joint liability in most tort claims is now so focused on several only liability that we've been misled, because in libel cases, it is still joint liability.
So, counsel, I want to ask you, I mean, this is, I want you to help me with something, because I'm really trying to figure this out as best as I possibly can in terms of what the implications of this could ultimately be. I'm focusing now exclusively on civil. And let me just give you an example. In many situations, and I'm going to speak of my litigation before I came to this court, when you do a lot of folks that do public service work. So if you're doing civil rights, if you're doing public service type activity or that kind of work, often is the case, it can sometimes be a David versus Goliath struggle. You're going to have, certain attorneys that are going to do things in a public service realm. They're not going to have the resources that, let's say, the defendant is going to have. So often is the case that the ability to tell their story to the press and to allow for the press to shine a light as to what is happening is going to be critical in terms of the public's right to know based off of a litigation strategy. And it can ultimately affect the behavior of the defendant. If you remove the ability for public interest attorneys or folks that do this type of work to be able to work closely with the press to expose and shine a light as to behavior and conduct that a defendant might be engaged in, that can create a tremendous shift in power to allow for the defendant to basically outspend the plaintiff in basically making it very difficult for them to put forth their case. I'm going to give you a very quick question now based on that background. A statement like this, I'm just thinking of my own litigation, a statement like this, I'm going back to when I was litigating with the University of Michigan over the stadium, and it engaged a lot of battles between myself, my clients, the Paralyzed Veterans of America, and the president of the University of Michigan, Mary Sue Coleman. If you were to make a comment such as this, it is, that President Coleman does not care about people with disabilities, that President Coleman is restricting the ability for paralyzed veterans to have access to the football stadium, that the University of Michigan doesn't care. I'm giving you examples of intense language that is used in media interviews to basically allow to the public to have an understanding in a very direct fashion as to why you're bringing litigation and what the litigation means to certain people. Would that be, if this court were to rule in this manner, would that be actionable? Would the University of Michigan then be able to then pursue, let's say, the paralyzed veterans in this hypothetical that I'm giving, or the lawyer, which would have been me in that situation, under this theory?
I mean, respectfully, Justice Bernstein, I think that it would be. That's that under the rule that the Punturos and that the lower court adopted, it would be actionable because it would be defamatory. It would negatively, it would shine a negative light on the University of Michigan's ability to do business. And I think that the point that myself and Mr. Zelenock have universally agreed on throughout this litigation is that this involves line drawing, right? And we want to make sure that we're not chilling free speech. We also don't want to create a license to defame. When we have guardrails that push back against the ability to freely defame, we want to make sure that the privilege means something. And especially when we're talking, like, not just about attorneys, right? Those were important, but real people are important too. We don't want to force everyday average citizens who are talking about their lawsuit where they're trying to vindicate their rights, or criminal defendants who are talking about an ongoing prosecution. We don't want them to have to employ technical language or hyper technically talk about that. We don't want. I think the legislature's amendment to the section in 1988 in the Court of Appeals substantially represents standard reveals that we want those people to be able to speak close enough standard.
Very quickly, could this wind up triggering a whole litany of litigation that basically now you're going to have litigation on top of litigation? So, now everyone's going to start suing everyone over every statement that people ultimately wind up making in the public forum?
Yes. I mean, particularly following up on Mr. Koch's answer, I mean, the answer to Justice Bernstein, your first question is yes. I mean, of course, the lower court's rulings would allow lawsuits against the Paralyzed Veterans of America, your law firm, yourself individually. The correct ruling, if the court applies this court's jurisprudence, the correct ruling would be as long as the CBS interview or the Free Press article that recorded and reported your interview made clear that this was a contested case and you're an advocate for one of the persons and it hasn't been decided yet. In other words, as long as that article was not itself entirely libelous and as long as it was a fair and true report, the privilege applies. And that is the critical thing here. And that's key to the error the lower courts made and the Bedford v. Whitty court made here.
And I have one last question, just because, and you're going to just help to educate me on this.
Bernstein, we are very, very over time. Is this last question really, really important because nobody else has gone yet and we have used up twice as much time as we have?
I'd like to ask my question.
Okay.
I think it's kind of important. The question I'm going to ask is dealing with public officials. Would this, and again, I don't want to, I mean, it gets more complicated. I get it when you're dealing with public versus private individuals. What would the impact or the effect have if you were in litigation with, say, a mayor of a city or that type of situation? Would that, again, I get that it's more complicated, but would that have an effect?
Sure, because the public nature of either the plaintiff or defendant, depending on whether the municipality was suing somebody or a defendant, could add additional layers of both other defenses and privileges involved at law, and then also heighten the concern about free speech issues and issues of public concern. But it's hard for me without more facts and thought to address it beyond that.
Thank you, counsel. Now I have no further questions.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
I have one, but it will be quick. Because I think it's a rather direct answer, or should be. My understanding is that your position is that the report, as in terms of the language of the fair reporting privilege under the statute, the report is the media report of that. So it's the Record Eagle article. It's the video and or statement issued by Channel 9 and 10. It's the entire report. So if that is can you tell me your position of whose obligation is it to actually make that entire report part of the record? Is it the plaintiff in the complaint, or is it the defendant who is asserting or seeking summary disposition because of that the entire report actually is true and fair?
So if you're okay, Jay, I'll field this. I think that the answer is if, at the summary disposition stage where we're working with the allegations in the complaint, I don't think that in this case we needed that. I think if we went to trial, it would be the plaintiff's obligation to support their claims. But in this case, we at least we believed we had sufficient allegations in the complaint to argue that the context was focused on these lawsuits, right? If you look at paragraphs 28 and 29, I think those make clear that these articles were about the lawsuits. We thought we had enough context to make those arguments.
Okay, thank you.
Justice Markman. Justice Markman, do you have any questions?
I have no questions. Thank you.
Justice Zara.
No questions. Thank you very much.
Okay, thank you very much, Mr. Moothart.
Thank you. May it please the court, John Moothart on behalf of the Appellees. Counsel started argument with the statement that there are 3 ways to discuss a criminal case that's pending. If you're an attorney, there's 1 way to discuss it. And the roadmap for that, call me old-fashioned, but it's set forth very clearly in our ethics rules. Rule 3.6 tells us, do not speak in unequivocal terms. It says, without elaboration, you can provide basic facts about the case. You don't comment on guilt or innocence. You don't even say that a charge has been filed in a criminal case, unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty, period. If you're an attorney, that's the way it's done. There aren't 3 ways, there aren't 4 ways, there aren't even 2 ways. There's 1 way. In this case, the the defamatory comments made by Mr. Kern followed specific threats to make those comments. He threatened to make these statements in the context of saying that the press was going to blow this up into a bigger story, threatening that he would help blow it up. He said it would be better if the judge sentencing Mr. Punturo after the criminal case was over with never sees this whole nastiness plays out. He compared this case to one where the same judge, Judge Rogers, had 4 days before sentenced a criminal defendant to 25 to 50 years and said, you don't want that to happen to your guy, do you? He offered to refrain from making these statements and instead to say nice things, quote, to help get your client out of hot water, unquote, in exchange for $750,000 settlement. When the payment was not made, he and his clients made statements just as threatened. Nobody in this case, neither of the defendants have even attempted to explain how per se defamatory. These aren't statements about somebody not caring about the disabled. As bad as that is, it's terrible if that's true. These are statements that someone committed extortion, a 20-year felony. Nobody has explained how doing that, especially as in fulfillment of a threat to do so, to try to collect money by an attorney, could possibly be fair or true. We've argued in our papers, and I'll get to that if I have time, that this is not a report at all. It's not a report of anything. Justice Viviano alluded to that. It's not a report of a proceeding when you don't talk about the proceeding, but instead you talk about how it's a vindicating day for my clients, and I'm glad the Attorney General takes extortion and antitrust seriously. And I've never seen an antitrust case with extortion like this before. I don't know where that, you're not going to find that in the public record anywhere, any of that stuff. And I don't have time to go through it all. Our complaint recites verbatim these statements. But on the fair and true aspect of this, the Court of Appeals in the Smith versus Anonymous joint enterprise case, it's an unpublished decision and it's on remand from this court's decision. But they talk in that case, they cite the Random House Webster's Dictionary about what is fair. And again, fairness and truth. What is more important to our profession than those two things? I can't think of anything.
Mr. Moothart, let me interrupt you. Let me interrupt you and see if my colleagues have questions, because it's some of them I think I bet will. So why don't we stop right there for a second, and I'll start with Justice Viviano.
Thank you, Your Honor.
No questions. Thank you, counsel.
Justice Bernstein.
One very quick question. I'm trying to understand, counsel, I appreciate what you were indicating in terms of the criminal civil distinction. I just want to get very specific clarity on this. Is there a distinction as it pertains to how this court would rule, as pertains to your argument, between a civil and criminal distinction? Is there a distinction between saying that somebody is going to be charged with a crime versus issuing a statement against someone in a civil capacity, accusing them of doing something wrong in a civil context?
Thank you, Justice Bernstein. I mean, to the extent that the ethics rules do matter, there are additional requirements for comments to the press about criminal matters. I've cited those in just now and in our brief, but those are not limited to criminal cases. As attorneys, we are somewhat constrained. Our First Amendment rights are somewhat constrained by our duties to the profession, to the public, and to the fairness of the proceedings. And there is a duty to refrain from saying things under Rule 3.6 that could prejudice as an eventual fact finder. I can live with that. I said, call me old-fashioned, but I'm not the standard bearer. But when I get a call from the newspaper or the TV station, I get Rule 3.6 out and read it before I talk to anybody. I don't think that's such a huge burden, given the privileges that we have as attorneys and the the position that I hope we all have in our communities and in our society. It's not a huge burden to choose our words carefully and to be liable for it if we don't choose those words carefully and appropriately.
I'm going to ask one question. I just want clarity on this because I just want to make sure I understand exactly what the arguments are, and I want to have just as much clarity as I can get. How would you write? So what you're saying is this: it's not. It would affect criminal and civil. And how would I write an opinion as it pertains to an attorney speaking to the news media on a case that they feel strongly about where they're participating? How do I write an opinion that basically sets forth the guidelines and standards for a person's ability to speak, offering an opinion on a specific case when they're talking about a defendant's conduct in litigation?
Right.
Well, what is appropriate? What's inappropriate?
One thing that one safe harbor would be to talk about the proceedings and not about the alleged acts of the defendant, and to follow the rule. I mean, Rule 3.6 is not causes of action can't be based on the ethics rules, but we cited the case law that talks about how they can be used to define standards of care and to support causes of action. There's certainly admissible evidence. And in this case, the rule says without elaboration. Don't go on and on about it. There is if it's a report of a proceeding, the first thing, and I think the thing that would be the most forward in the discussion would be there is a proceeding. There was a meeting at the township hall last night. The planning commission met, and here's what they discussed. There's a complaint on file with the court. Here's what it says. So make it
in your argument would be and there'd be no elaboration. You wouldn't elaborate.
I'm not arguing that, Justice. I'm just telling you I'm just mentioning what in the context of criminal cases.
No, I get criminal. I'm just trying to understand if I'm writing an opinion, what that means for criminal and civil.
Well, Rule 3.6b applies to both.
I see.
A lawyer
Okay.
who is participating or has participated in the investigation or litigation of a matter may state without elaboration. That's what it says.
I get it. Okay, counsel, thank you very much.
Justice Clement?
No questions.
Justice Cavanagh?
I don't have any questions.
Justice Markman?
I have no questions. Thank you.
Justice Zara?
No questions. Thank you very much.
You may continue if you like. You still have additional time, Mr.
Thank you, Your Honor. I was just discussing what the Smith v. Anonymous Joint Enterprise definition from the dictionary was that the Court of Appeals discussed in that case on remand from this court. That definition, as cited by that court, is fair means free from bias, free from dishonesty, free from injustice, legitimate. A lawyer going to the press in fulfillment of a threat to defame his opponent because that opponent didn't knuckle under and pay the money he asked for is not an unbiased individual going to the media and providing a fair report of litigation, a fair report of the pending criminal charges. It's not fair. It's not free from bias. Was it honest? Was it legitimate? I mean, I can understand how in this context, there may be fact issues that might need to be vetted about, the nature and extent of what the plan was and why these comments were made. But this, as a matter of summary disposition for the defendant, is not a fair or true report. And as indicated, it's not a report. I mean, it has to be a report of something. A proceeding, a public record, an action of a public body. We cited Judge Spector's opinion in Merritt v. Thompson, and as a bankruptcy attorney from way back, I have a lot of adoration for Judge Spector, which may not necessarily be shared by, he might not be known by everybody, but I think his opinion is very erudite. There's a subtle but fundamental difference between saying I testified at trial that X is a pervert versus X is a pervert. Because the latter assertion describes the speaker's present state of mind. It clearly goes beyond the simple recitation of a fact that can be verified by reference to court documents. This is the holding of Bedford. The Court of Appeals in this case, which by the way mentioned on the fair and true issue, despite the content of the public record, defendants stated in no uncertain terms that Punturo committed extortion and flagrant violations of MARA. I think that's a good observation. These were not made in accordance with the public record. They were made despite, as the Court of Appeals said, despite the content of the public record. But Bedford, when it talks about one example, the lawyer in that case said, we can say with certainty that these crimes were committed. As we've indicated in our papers, whether someone says, I'm saying we can say with certainty, or they just say it with certainty is not a distinction. But when you say said with certainty, is this such a difficult standard to apply? Is it so much to ask to be, as Justice Viviano indicated, a little more careful with our words, especially as attorneys? And we're duty bound to choose our words carefully. When they say, when the Court of Appeals panel said in Bedford said with certainty, I think that means saying this with certainty about allegations, that mere allegations in a pleading in a court file, said with certainty means it's not really a report of that proceeding. It's not fair. It's not true. It's not merely summarizing what was alleged in the litigation. The statements do not substantially represent the proceeding. Those are the standards. Those are the standards that we have and that we are dealing with in this proceeding. Something has happened.
Counsel, can I ask a question, please?
Yes.
Throughout the realm of First Amendment law, don't we tend to err on the side of allowing more speech rather than less speech in almost all circumstances so as to not chill a proper speech? Shouldn't that same general standard be applied in the instant realm as well?
Justice Markman, I'm aware of there are certainly rules about the application that are, are handed down through, New York Times versus Sullivan and cases like that. First Amendment does regulate these things, but accusations of criminal conduct are not First Amendment protected. They're not. I mean, it's per se defamatory. I don't think. I'm certainly. It's important to protect free speech. I understand that, but we cited the case from Indiana in our papers that the First Amendment does not give lawyers carte blanche to defame their litigation opponents. And,
well, they would be protected. Such statements would be protected, at least if you introduced a prelude to the effect that, of course, this is merely an allegation and it has to be resolved in a court of law.
Yes.
It would be protected under those circumstances.
It would be, Justice, and as we indicated in our papers, the Attorney General's press release in this case is a clinic on how to do it correctly, as Justice McCormack observed. It's not that hard, and it's not that much to ask. Just get the rule out, take a look at it, and follow it. And don't defame your opponent. Don't threaten to defame your opponent unless they pay a lot of money, $750,000, and then when they say no, go out and do it the next day as planned. I mean, this is not who we are. If there's a dangerous precedent to be set here, that could be set here, it would be to say, lawyers, don't worry about the ethics rules, and don't worry about right and wrong, and don't worry about justice or fairness. Just if you want to defame somebody or you want their money, sue them first, and then tell them, I'm going to go and tell everybody in the press what is in that complaint, but I'm not just going to say there's a complaint on file. I'm going to repeat the allegations in that complaint. You are a child molester. You're an extortionist. You committed flagrant antitrust violations. You did this. You did that. I felt like I was being extorted every day. I hope he doesn't hurt anybody else like he hurt me. Those are that. If you want to look at the context, the deeper you go into the context of this, the more you see that this was we believe, and we've alleged, a designed and plan between lawyers and clients to go out and attack my client, kick him while he's down, accuse the things he didn't do in order to extract a lot of money from him in order to get some relief from that. And that I think would be a bad thing to have enshrined in Michigan law is okay, because we don't think, to use a real technical legal term, that is not okay.
Justice Markman, do you have further questions?
No, I don't. Thank you.
Okay, thank you so much, counsel. Your time is also more than over. You all did a nice job. Thank you very much. This case will be submitted.